Yeah, they were. We could have like 3:45 of us drops in the front door.
Let's keep going. Okay, good morning, everybody. Welcome again, and I say that because you keep showing up and giving us input, and I see some faces, well, familiar looking names, people I haven't met yet. So my name is Katie Ratcliffe. I'm the Water Rights Services Division Administrator for Oregon Water Resources Department. And here with my co-sponsor, Raquel Rancier, Deputy Director of Strategy and Administration. So we're excited to be kicking off meetings 6 and 7. Those are both occurring today, so the morning session and the afternoon session. A few logistics in case anyone hasn't been here before. Bathrooms are to your left, elevators to the right. The stairwell is also to your left if you need it. And then please feel free to help yourselves with any refreshments over there.
Okay, so just a brief overview of how the day is going to work. So even though this is noticed as 2 separate RAC meetings, we've merged the agenda. We're just going to kind of go with the flow. We are going to stop at noon and restart at 1, and that's for the virtual folks, because we did notice this as 2 separate Zoom meetings. So you'll need to sign off at noon and then sign on to the RAC 7 Zoom link. We'll put that in the chat for folks, and we'll remind you. I have a slide with the link and all that, but we'll remind you, make sure everybody is able to get back into the meeting at 1 o'clock. I've got some schedule reminders, and then we're gonna walk through Division 382 and Division 77. We'll see where we get at noon. I'm guessing we'll still be carrying 77 over after lunch. And then after that. Or not. Depends on how fast Raquel talks. Then we're gonna get into those draft notices that have to accompany the notice of proposed rulemaking. So the statement of need, racial equity impacts, and fiscal and economic impacts. That portion of the meeting will be more of a discussion. So we're really looking for input. We're gonna review sort of the statutory boundaries. What's going on here? Statutory boundaries. That says I've left the meeting. That's interesting. Okay. Hold on a second. Yeah, it's not sharing now. I'm sorry, let me make sure. Is the meeting still running on your end? So I shouldn't restart it.
Are you on WD Wireless?
I think I was, yeah. Okay. Give me a second. Make sure my slide shows up here.
Yeah, it says you're gone out of the meeting.
It says I'm gone. That had to restart the meeting. Sorry about this, folks. Got booted off this. Okay, sorry about that. So again, we're going to talk about those statements after lunch. We've got sort of an outline as to what the rulemaking need in our view is, and we'll look for some feedback from you. And then the racial equity and the fiscal and economic impact portion will be more of an open discussion, really soliciting input. And then if we finish all that, and there's time remaining, we might start digging into revisions that we've made to 14, 300, and 320, including some proposed changes in 330, which are related to comments we received regarding 320. And Raquel will go through that if there was time remaining. And then we're going to allow time for public comment and then wrap up the next steps.
Laura, can we pause it for a second?
Yeah.
So, raise your hand if you have read our documents from 14, 300, 320, 330. Okay. Well, we've got
I
a
sent
couple
'em, yeah.
overachievers here.
You got them
So-
yesterday and they're posted on the website. but
Yeah, so just so you all know, if you didn't, that's exactly what I expected, so.
Yeah,
Don't freak out, it's okay, because that's exactly, what we will walk you through it, but you don't, need to have actually reviewed the documents. If you did, then you're like top achiever of your class here, so, okay, thank you.
Are they getting over here?
Yeah.
Yes, they're
Everything's
over here
printed out,
and,
so.
we can walk through them later in the day if we get to it.
All right, so,
I just don't want people panicking. I know where we're all at right now, it's just tired, so, okay.
I'm having technical difficulties already. Yeah, so some reminders about some of the deadlines for input, our RAC, 3 and 4 meetings, so division 310, 18, 315, 17. If you can get those to us by the end of the day on Friday, that would be great. And then our RAC 5, that's where we really dug into 380. I don't think we started 382. So just 380, we were asking for that input by, November 5th. And 382 by November 5th. Did we start 382 last time?
No, but folks have had 382
Yeah,
for
okay. All right, so
a
we
while
can,
now.
we'll stick with that. And then I think, Division 77, that'll be on the wrap up, but I think we're targeting November 11th for that one. And then we have the Division 2 follow-up, virtual only meeting on the 31st from 10 a.m. to noon. That link is on our website as well, if you haven't, gone ahead and registered for that and are interested. I don't know, Raquel, if you want to say anything more about Division 2 or kind of how that's gonna go.
No,
Okay.
one day at a time.
Okay.
That's where we're at today, is one day at a time. I do want to note one thing. So one of the reasons it makes sense for your input to be due on 382 at the same time as 380 is we'll talk about today, they're very similar rules. And so if you have a concern on 380, you probably have the same concern on 382, right? For the most part, we'll say 90%. So that's why it makes sense. Let's do it once and then you don't have to keep repeating yourself, right? You can be like, I have the same issue with 382, so.
Does anybody have any questions before we start diving in? Online. All right. I'm gonna turn it over to Raquel,
All right,
and Katie, maybe.
so we are, Yes.
Just make a general statement. I appreciate the work you guys have done in this, but I just want to go on record that we would feel more comfortable if we would have done these rules just pertaining to the legislation and the cleanup rules on 2 separate
I hear you.
processes.
I hear you. It's hard to pull those apart, so. I understand, and also, we're all in the same boat. There's a lot of work to be done. So keep in mind, right, we still have, I know it feels like crunch time right now, so we've got, the deadlines that we have, right? That's to give us your initial input. You can always give us more input, right? So, it's helpful if we know what the biggest concerns are, right? So if you're really looking to prioritize, flag what the biggest issues are. And then just, note that, we've got time to make adjustments. We also have the public comment period, right? And so, I know this is a busy time. The public comment period will be in January, so you have an additional couple months to continue looking at the rules and finding, what items we may need to address in them, so. It's a balancing act, but just note, as a result of this rulemaking and participating on it, you are. Really moving water policy forward in the sense of we're cleaning up a lot of rules that, that are old and well, in a lot of cases out of conformance with statute, so. You're a part of that then.
Maximizing streamline.
So, we're all trying to be optimistic here. I know it's a lot of work and, so. We'll continue to evaluate on the way, but one thing I'll just note is it's really hard for us when we're going through a rule and, when we see. Something that just doesn't make sense to just leave it and be like, cool, we'll just leave it there and, let the future deal with that, so. Michael?
Yeah, just, I wanna kind of piggyback on something he said, just for good of the order. I think for me, since this is probably the most robust RAC that I've been part of, is one thing that's kind of percolated for me as a question is when I provide feedback and you say like, come, you've said, come to solutions, that's that Jeff Stone thing that, sort of, I want to kiss up here. I'm showing that, hey, we're working towards solutions. But how do I know when that feedback is being incorporated? Is it like at the end?
I love
Or
that question.
vis-a-vis,
Yeah.
like there's conflict and we just disagree?
So. Okay, so we're gonna change the order of our agenda a little bit for a second. This is Division 320, right? So we talked about Division 320 at our first RAC meeting. And you'll see one of the handouts that I know everybody has not read, except for a handful, right? On here, it shows the comment that we received. Many of these comments were at the first RAC meeting. Some of them were written comments that came in from you all after the fact. So it shows the comment, shows WRD's response to it. And then you'll see the status column, right? So for those of you that were looking at Division 2, you'll see that half of the stuff is complete and half of the stuff is not, because we're having a further conversation on a lot of those things on Friday. And me making a decision on them before we have that conversation, that would not be taking your input, would it, right? So we have the comments noted, but there's still an appending status. The ones that we've addressed, you'll see on here, change made or change not made. And in the column that says status version change made in, oh, this one, great, awesome. I love that this is not correct in terms of the headers. So this is the response. This is the status and the version that the change would be made in. We've been having issues with copy paste anyways. So that will show you whether or not we made the changes as a result of your feedback. The green is indicative of like, we consider the matter complete for the moment, right? You can provide additional comments and be like, no, you didn't understand what we were saying, right? But this will give you, we know there's a lot, right? Glenn, we know there's a lot, but this will tell you whether we address your concern or not. Also, if you don't see your concern on the list, then one, please know that that's not intentional. Please raise it so we can get it on the list and point it out to us, right? Because we're trying to capture a lot of information in these meetings. We're doing our best to do that. And so if we miss something, I apologize, please raise it. I promise it is not us just being like, oh, I don't want to deal with that, so I'm gonna leave it off the list, right? So, Michael, does that respond to your question?
Yeah,
Okay,
I'll jump in. For the.
okay, let's go for
Good
it.
of the order is. Will we have additional RAC meetings then added at the end? For group discussion on the revisions, if you have 3 potentially listed today, probably gonna punt those to a later meeting, depending on how the conversation today goes with everything else. So are we adding more to then go through the changes made or not made?
So
And then
yeah.
my second question is, we have now also today potentially added division 330. Are there going to be more divisions added to my ever growing binder of?
Laura, can you please pull up the schedule real quick? So Brandon, we already added the final 2 RAC meetings, right? We talked about that day, RAC 1. That is the extent of RAC meetings.
Okay,
We can't go into December. We have to do all the work to get these into the filing system in December and to make, final decisions. So,
okay,
so we are providing those, right? And
Right.
then we've got 2 meetings in November. And we are not going to walk you through every single change.
okay,
I will tell you, you all will thank me for that because some of the changes are like change US Geological Survey from a lowercase g to an uppercase G. If I walk you through every single one of those changes, you all will be bored, right? They're good changes, by the way, but you all can read that in the table yourself, right? We don't need to spend time on that. So what I will say is what we are intending to do is bring back substance, right?
Okay.
So there are some issues we know we need to bring back. Land use, Division 2. I know there's a longer list than that, but those are at least 2 of the ones that we know you all are gonna wanna talk about. So what I will say is if you have items that you're like, I wanna talk about this again, shoot us an email, let us know, and I suspect we already know that, right? Because we're hearing your feedback and we know whether or not we said, yes, this is a clear resolution, or, oh, this is gonna be something that we think folks will want to talk about. So that's how we're planning on managing it. So no, we're not intending to add additional meetings. The other piece is 330. The only reason, I was gonna say this at the end of the day, but when we get there, but 330, the only reason 330 is added is to address your comments on 320. We are not, I'm gonna say this again, we are not dealing with any of the other rules in 330. So don't look at them.
There's a lot that could be updated there, but it would take a lot of work.
If you look at them, just note that that will be my response, which is we are not dealing with the existing rules in 330, right? We are changing the title. And then we are making it so that the issue that you all acutely identified, which is it doesn't make sense what's in 320 versus 330, right? And now we're making them a very clean proof of appropriation will be in 330. So it's a renumbering, right? All the issues though that you identified on 320 that are in rules in 320 that will be renumbered into 330 will still be addressed, because we're not gonna just say, oh, well, we're just gonna renumber and then not take into account the feedback and the changes made to those. So does that help alleviate some of the,
yes,
okay.
thank you.
Yeah, Chris too.
Yeah, Chris?
Yeah, so Waterleak's position, which conveniently aligns with state law, is that the state has absolute preemption authority on writing rules. And there are a lot of RACs where people complain that they haven't had their things heard. I'm definitely somebody who loves to make sure that what I put in there is gonna be accepted. But at the end of the day, I have to rein in my expectations as to really what's gonna happen, because the world doesn't revolve around me, essentially. So I just want to make it clear that there have been a lot of RACs, especially the one that's out in the Horny Basin, where there have been folks who have not been clear as to really how this process works. And I think the Water Resources Department ought to, at the beginning of these sessions, like first RAC or whenever it is, clarify precisely what the roles are so that we all are on the same page. I, as much as anybody else, would love to have everything that I say get out there and be made into the law. But, that's just not gonna be the case. And so, that's our position. Thank you so much.
Chris, thank you for that, and I think we recognize that, and so you may recall the first day PowerPoint, which was like, this is the RAC's role, and this is the agency's role. We're happy to share that out again if that'd be helpful, but I think you were spot on that comment, and making sure that folks understand that, so we'll continue to work to do that. Other questions or comments, just as, since we're on this?
I'd open up the pan can of worms.
No, this is great, right? This is great. These are all legitimate concerns, right? And we also know that, there's been. Britton, do you want to do the statement of need right now? I feel like we're like tossing the agenda around, but I mean, as we'll talk about in the statement of need later in the day. Everyone's saying that our process isn't working, right? So we are working to fix it, and we can't keep kicking the can down the road on that. So you all are getting the joy of being in the boat with us. We've got a whole boating analogy for this rulemaking, by the way. I appreciate you all bringing up the concerns. And also, to the extent there's things that we can do to help you, right? Please, so that it's good to bring it up, right? Because we're trying to make sure that we're giving you as much leeway within the confines that we are in, right? So if there's things that you need, if you're like, hey, these deadlines are trying to help us move everything forward, you'll start to see how this process will unfold. You can still provide feedback after the deadline, and just note, it's probably not gonna make it on that little sheet in time for us to bring it back to the RAC, right? So. All right. Thank you. Let's move into 382. So speaking of attempting to make things as easy for you all as possible, because I do know it's a lot of work here, is a little grounding on 382. You will recall, we have our cover sheet in front of us, and one of the things that we attempted to do in going through these rules is identify where they're very similar to 380. Some of them are exactly the same as 380, except for they probably say groundwater registration versus transfer, or water rights, water use subject to transfer, things like that. But some of them have a bit of nuance. I've tried to go through and point out a couple areas where I think you all will certainly be interested. So with that, I'm gonna take us through the beginning of these rules here. Let me get to my pages. So we've got 382 minor change, or sorry, 0010 minor change there. Not going to go over that. Feel free to raise your hand or your placard. Oh, as a reminder, as a point of procedure, if you're online, please use the chat only for logistical issues. If you are wanting to actually discuss the rule and the substance, please raise your hand so the whole RAC can hear. Folks in the room can't see the chat, and I can't see the chat. So there we go. Okay, if we move into the definition section, these changes are similar to what we did on 380 and probably nothing new. So I'm gonna move us into the next one. Not seeing any hands. If you need me to slow down at any point, let me know. I did go through last night as well and tried to look through and see what comments we received on the 380 rules. where they had similar rules here, so I'll try to retain that in my mind as we go through here and point some of those out as well. Okay, so the next section, we've got layered water rights here. And again, similar changes is what you saw over on 380. And then we get to 300. This is just a technical fix to point to a rule that elsewhere in this section for clarity. And then we get to 400, and this is where I want to probably put a little more context for you all here. So, this looks like a lot of changes. It doesn't just look like, it is a lot of changes, right, to this particular rule set. And so many of these changes are proposed to make it so that the groundwater registration modifications are following the same process as transfers. So if you look over at the transfers rules, you'll see the similarities there. Okay, so that's part of it, is that the GR mods, they were lacking some of the rules that already existed in the transfer section. Some of it is that we made changes to the transfers and we're trying to standardize the processes. Some of the background on why we're trying to standardize processes is because it increases efficiency. We don't have to figure out, oh, we're doing this particular type of transaction, now we need to go do this particular process, and we have a different, you know, approach and checklist and all of these things. That reduces the learning curve for our caseworkers. It also reduces the likelihood of mistakes because we're following the same process. Lisa, how many different processes do we have right now under your?
Under transfers?
Yeah.
Under the transfers umbrella, at least a dozen, if not
Yeah.
15.
So the more we can standardize things, the more we can have those efficiencies and also reduce the likelihood of mistakes. So we have in here the these also are trying to make standardizations across mapping. So some of the mapping provisions, right, we know are in 305. There's also some provisions in 380 that are specific to transfers that are lacking here in the GR mods provisions. So those have been added. I do want to make note that in addition, so if you look at 380, 3000, that's where a lot of the application requirements are. What I didn't put on here is that 3000, I think, then points to 3100 and 380. So the mapping standards in this rule are similar to 380, 3100, if you're trying to compare across. And Greg, I see you. I will get to you here in a minute. Just give me a moment. The other piece I want to point out is there is some slightly different standards in here as it pertains to the application requirements and then later in the completeness review and, you know, approval. So I want to point those out because I know that's actually will save us maybe some time because some of them were a lot of discussion over in transfers and they don't exist here. There is a different one though that exists here that's not in transfers. So I want to make sure that we flush that out here. So if you look in here, there was, you may recall, a lot of discussion around evidence of use. And this is, and Katie, Lisa, if I'm misremembering this, feel free to chime in on this, but we don't have that same provision here for groundwater registration modifications. And that's because of the nature of these rights, right? So whether forfeiture or abandonment has occurred, that would need to go through an adjudication process, right? When these rights are determined. So remember, these are registrations, so they're a bit different in terms of the type. So we're not determining that here. So The application requirements don't have that evidence of use language. Also note that, there's language used as you're looking through this, that, it uses the term recognize. That's the term that's used in the statute as opposed to like approved or denied, those kinds of things. Because that's, you know, how this is done in the, because they're different kind of, right, we're recognizing that they're making a change here. They also have a tentative priority date per the statute, so when you see we made that change, again, it's mirroring the statute. Because again, this all has to go through an adjudication at some point in time to get the defined, to affirm that. So that's some of the language differences that, are because of the nature of the right. I'll also note, because we've heard a lot about land use. We know that folks have concerns over the land use form that is included in here. We haven't updated the language because we don't have a solution yet, but I know that we're continuing to talk with Brandon, and I'm sure Brandon's talking with Michael, so we're all still trying to figure that one out. So I want to acknowledge that up front. We know, we've heard it, and we're still working on it. Greg, thank you.
Yes, good morning. Hi, it's Greg, Oregon Groundwater Association. Just real quick on the tentative priority date. I'd looked to see if that was defined anywhere, and I didn't see that. So, I mean, is there a date on the registration that's would be considered the tentative priority date?
Yes,
I just don't know.
yes.
Okay, so do we need to put that in the definitions of what that date actually is?
I don't think, I'm not inclined to add a definition for that, Greg. I mean, I think it's basically the priority date. It's just tentative because it hasn't been adjudicated.
Well, I mean, but is it the date that the registration was submitted to the department? I mean, you know.
Lisa's got an answer to this.
It's the date when they began construction and it's identified on the registration itself.
And Greg, I'm not inclined to define that because this is about groundwater registration modifications. This is not about submittal of a groundwater registration. And the priority date issue was when all of those were dealt with. So I don't want to get into anything about submittal of a registration, if that makes sense. This is about changing one that already exists.
I might add, and I haven't looked at it today, so I'm a bit fuzzy, but I'm pretty sure the statute 537-610 identifies that it's at the beginning of construction.
Okay,
Does that work,
Thank you.
Greg?
I think so, yeah.
Okay, Ted?
Good morning. Yeah, I had a question. Maybe it's just a point of clarification on this particular page for items 8, 9, and 10. I see the language was changed from authorized to existing registered. And I'm just thinking of the situation where someone has already done a modification and they're doing potentially another one. And I'm wondering whether the language should sort of say, you know, existing registered, which is what would have been on the original registration, or recognized in the case where they may have already added a proposed point of appropriation that's been recognized previously by the department. That might make that more clear, because the way it's written, it seems to just reference what's on the registration. And I don't think the registration is formally changed through the modification process.
Okay, we've taken that note, sounds like we may need to refine that based on the whispers I'm hearing over here, but I'll be honest, Ted, I'm not sure I fully understood that, so I'm gonna digest it. It sounds like Lisa's already digested it, and Bryn's taking that note down, so we'll take a look at that more closely. And I'm seeing a thumbs up from Greg, so. Chris.
Yeah, just number 11, the map doesn't need to be prepared by a CWRE. And I was just scrolling through, what is it, A through G? And some of those are fairly complicated. I wonder, who can comply with the new standards in Division 305 that is not a certified water right examiner? I mean, could I theoretically, do that work? And then second question is, what's the background for this? Where did this come from?
Chris, thank you. That was one of the items that I flagged, so now I'm gonna put it on them on the spot. When I was looking at this last night, I was like, oh, that's interesting that we don't require CWRE for GR mods, but we do require it for transfers. So this is one of the differences here. I suspect it's because it goes back to that nature of the right, but Lisa, is this just a carryover from the existing rules, or did we kind of talk about this and say, no, we affirm that this is?
I believe it's carryover, and
There any reason on this, putting you on the spot, that there should be a difference where we don't require it to be by a CWE for a GR
think
mod?
maybe the reasoning is that we're not making a final determination on anything through the groundwater registration modifications, since that's all done as part of the adjudication. But I think it's a fair note for us to look into a little bit further.
And we also do have a number of processes, Chris, that don't require a CWE to prepare the map. So the new water right application process is one of them, where we do require a CWE to prepare the map for reservoirs above a certain size or storage amount.
Sure.
But folks do come in and prepare their maps for other types of applications for new water rights. Sometimes that means there's a lot more back and forth between the department and folks about how to get to a sufficient map, which is what Division 305 is attempting to help them do.
And that's the same with temporary transfers, permit amendments. We don't require CWREs on those either.
So Chris, I think the answer is theoretically, yes, someone can do that. Kimberly.
Yeah, 11B, it seems to imply that there can be a proposed modification that includes more than one groundwater certificate of registration, and as we have said before, we think each water right being proposed, or not here, each groundwater registration that is being proposed to be modified should go through the process and it rather than something together.
Yeah, and I know we had talked about that briefly. I believe this one and 380 is similar comment, and I think this one also has the same limitation. Although I don't know what rule it's in about the number of.
I thought that in the transfers, later it was one, but this seems to imply.
In the transfers, it's one unless certain things are met, and I think the same applies here, but.
Yeah, with a transfer, you can have one water right certificate per application unless certain criteria are met. In the GR mod, it's one GR mod per application. But I should say I should restate that, one groundwater registration per application, but we allow multiple changes under that mod. And that's your point.
Yeah, I don't think this reads that way.
Okay,
I guess I would
doesn't.
just, I would have
Okay.
to look at that.
Okay.
Thank you.
It's 11B. So we will need to take a closer look at that, because I read it the same way as Kimberly did.
Okay.
That was another one that I had noted to myself that was gonna come up today, so.
It's probably tied to the layered element, so I'll.
Yeah, and I couldn't find it when I was kind of prepping last night of like, where was that said? Um. Okay. Let's see.
Oh.
So.
It's at the. I know what you're talking about.
Yeah, I know it's in here and I just could not for the life of me find it last night, so. Kimberly, I'm gonna say we've noted it,
Okay, that's fine.
and we'll see if we can find the provision that, that may be applicable to, and if we need to refine it. It's like you said, I read it exactly as you did, and then I couldn't find the language of like, I think we have the same provision there if there's certain criteria that's met, so.
Okay.
Anything else on this one? Okay, so I want to go briefly to page 7, so we're still sticking on this one. And I know fees are always an important issue for folks, so want to make sure that we flag this one for you. And for this one specifically, the fees are, the cap on the fees are set in statute. So the cap was set in the 2025 legislative session. And the actual specific fees are set in the rule itself. Now we did a little research here. So the current fees that are in rule, basically you have one that goes to the cap, and then you have the other one is basically 70%. If it's just a fee, or if it's just a POU change only, it's 70% of the cap. So we took those same amounts and basically just did it for the new cap, right? I will tell you that based on, I asked Lisa, hey, how does this compare to transfers? And I'll just say that the GR mods are getting a bit of a better deal than transfers. So with that, at a minimum, this is a proposal that is not trying to overreach on fees. How's that? So. Go for it, Lisa.
If there's no discussion about the fee, I would like to jump back to Kimberly's point, in 693-82-0300. Section 2 is where we talk about the application may propose modification of only one GR, one registration unless it's layered.
Okay, so that 3 would apply only if it's layered. I think we should tighten up the language.
Yeah.
Just, that took us 5 minutes to find. At least 5 minutes to find, that's too long,
Not
right?
good, yeah. Understood.
All right,
The 300.
so, yes, what?
When you have a cap, are all fees always up to the cap? Because if you say, thank you, 70% of the cap, would that be set, could that be higher than maybe another fee because you didn't use the cap?
So, almost all of our fees are set explicitly in statute. Right?
Right.
And so, as in, it's not a cap, it's a, this is what the fee is, right? This is one of the few ones that is set as an up to, quite honestly. I would love to just put it in statute and then it's all done at once, right? And we don't have to. Well, often it doesn't get adjusted in a rule, right? Because there's a whole, process, a separate process, even though the cap got increased. So, in terms of the cap piece, that's why we pulled the transfer data, which is akin to, which is set in statute. And, it's not an up to, and we looked at what folks were paying over there to then say, oh, GR mods are paying less. Even with this fee adjustment, they're paying less. So I don't know if that exactly answers your question, but, I think the short answer is they're not paying more than other folks.
It just seems like to me, if you say percentage and and don't define the cap, then it.
Oh, the cap is set in statute. Yeah,
Yeah,
sorry about
right.
that. I misunderstood.
Yeah,
The cap is explicitly in statute.
so if it's, anything other than the place of use, we'll charge the max, the cap. And then if it's only place of use, then we charge the 70% of that.
Yeah. Thank you. Sorry, I misunderstood the question. Okay. So. Seeing any more hands or comments? So I'm gonna take us over to the next one, another one that, oh my gosh, there's so much red here. And so as a reminder, the reason there's so much red here is this is basically making the process like the transfers process. So the comparable rule was 4,000. There is a couple distinctions here. And I'll note that we are doing the 2-phase approval approach, right? Where you have the initial review and then the PFO. And the PFO can become a FO on 33 days after, right? As we've seen in all of these different processes for standardization. So where I do want to draw your attention though to is there's, it is subsection 3. In particular, there is a different standard, again, partially because of the nature of the right. And so you'll see again that the forfeiture provisions that we talked about the last go around are not here. Again, for the reasons I mentioned before. And let's see. There is also a provision in here that is about state scenic waterways. So this is different than transfers, and that is 3B. So that is a different standard. That standard is not a new one that we've added to the rules. That is one that already exists in these rules elsewhere. So this, remember, is the initial review. So it's repeating essentially what is in 690, 382, 700, 2B.
Could you repeat that again, please?
So
69382.
690, 382, 700, 2B. So we'll look at that one shortly here. But
Thank you.
that one, if you look, B is already an existing rule. So this is pulling that standard forward.
And that's been in place since the 382 rules came into being and whatever that was. Those things. So,
Ted,
Yes, thanks. I have a question about this particular section. It's 3 sub D. Just trying to get clarification on what other requirements the department may feel are applicable to registration modification. It just seems sort of a vague statement as to what that is supposed to mean.
so Ted, thank you for that. I knew that one was also gonna come up, so thank you for that and pointing that one out. On this one, I think we need to make a bit of a change consistent with the discussions we've had in prior RAC meetings, where I think it's mostly been coming from Jeff Stone, who's not here today, I don't think, but who had concerns about this as well. And so, we will take a look at that, and I think the key is that, we'll be looking at language that says, you know, as provided on our rules or statutes. We need to evaluate whether we need to point out any other agencies' rules or laws, but, we will be working on language. That is another one of those holistic issues that we need to bring back to the group.
I'm sure what it's been.
Yeah, so Lisa's gonna share with you what it's been.
Yeah, so Ted, how we have been applying that is, any other requirements such as if we identify a layered registration that's not included, or later on in, this rule, we talk about, the applicant has to provide a report of ownership. So those things that come throughout our processing of the GR modification, could be if we identify a deficiency and we're asking for that deficiency to be resolved.
So basically, it's everything that's already required by our rules.
Yeah.
So if we ended up going with
Yeah.
the language that we've discussed in prior RACs, that's basically what we're talking about.
Yep.
Yeah. Thank you, Ted, for pointing that out.
Yeah, and I think like a reference back to those specific areas would be helpful, because I think we may all understand what this means now, but you know, down the road, different people involved, if it's not clear what that means, it's going to be open to sort of interpretation as to what that may apply to.
Ted, I would be inclined, just because I'm trying to keep our rules short, I would be more inclined to say, you know, as provided in these, you know, Division 382 rules and, you know, other rules of the commission. I don't know that I want to go with the full list because they're already provided in these rules. You know, the layered issue is provided in these rules, so we'll work through that. I do think we can provide more specificity. I just also, I want our rules to be shorter and clear and transparent, right? Because there's that balancing act of the longer your rules are, that also creates its own set of challenges from a transparency standpoint. Thank you for that. Greg?
Yeah, I agree with what Ted was just saying. I mean, I think, you know, of course, I understand the, you know, the interest that we have of keeping these things short, but you also said clear. And clarity sometimes requires specificity. And yeah, I'm concerned, as Ted is, that, you know, we get down the road here and, you know, somebody else that maybe doesn't know anything about the history of that particular rule and could potentially use it to come up with other standards. So yeah, I think it's important that the rules, yes, are brief, but also clear. And as I said, again, clarity sometimes requires some more specificity.
Thank you, Greg. We'll take it under consideration, but I'm more inclined to just reference 382 than to provide a long extended list, but we'll evaluate that and see. Okay, other comments on this?
Quick question,
Yes.
just regarding 3B, the reference to the state scenic waterway. Wouldn't that have been addressed originally when the permit was first being processed?
This isn't a permit, this is a groundwater registration.
But this isn't the very first time that this has been looked at, is it?
So groundwater registrations are not adjudicated water rights, right? They're essentially saying, I have this right, I've began this use, right? And they were all probably, yeah, submitted in the 1950s, right, when the groundwater.
Before the groundwater.
Yeah.
Yeah, it was adopted, so, so there hasn't, until it's adjudicated, there hasn't been like a, you know, full vetting, as
So
long
this-
as they met the standards of the groundwater,
Mhm.
you know, registration process, right?
This will be the first time that you've ever looked at it then for a scenic waterway.
Yes.
Okay, that's my
Yes.
question.
It's making the change, yeah.
What is the impact that could occur because they've been going along ever since, and is there,
So this would be the impact as a result of a change. It's not the impact as a result of the appropriation as it exists.
okay, yeah.
Yeah.
Thank you.
Okay. I'm going to move us then along to um 382,600. This one, I didn't really flag anything for us to discuss here. This is kind of consistent with so 4,005 under 380 and just the steps for requesting comment. And then 700. This one is the one that I just noted, where the existing rule requires the state scenic waterway piece. And again, I think all of these other changes are consistent with what you've seen in other rules, which is, oh, Leah.
Oh, on 702B. It's just been reworded a little bit. This is about the state scenic waterway, and if this means the same thing, then that's fine. But does receiving less water than previously available mean exactly the same thing as not receiving water that was previously available?
I believe so,
Okay, so if the intention is that's the same,
but
it's
maybe
not like, I don't know.
but
It just
we
seems-
should look at it and make sure we're not. I think
Before-
that's a good catch, is
Yeah, before it exactly matched the language in 553B. And now it's like a little bit tweaked, and I just want to make sure that that means the same thing and it's not gonna trip us up.
The intention is that it means the same thing, but yeah, thanks for pointing that out.
so we'll take note of that and look to adjust it to make sure it continues to mean the same thing. Okay. So you'll see some of these things that have been struck have been moved into the other. Into 550, because we're moving things forward in the process, right? So. 800. This one is the notice of the proposed final order. This is really about a little consistency across the different processes and implementing those items that I think we've already seen pertaining to protests and publication of notice and electronic documents. So I'm gonna keep this moving unless I see hands on that. 900 again, same language that you've seen. Kimberly, I know that you've asked us a question about party status. It's on my to-do list as it pertains to this 900, well, all language that looks like 900 throughout the rules, so I've got that noted. And then we get to the final order on recognition. That's that 33 days that you've consistently seen throughout the process. And then just watching the flipping of papers. That's why you're all getting these pauses, is I'm paying attention to the mode in the room here. Sorry, folks online, if you're already there. 1100 is, is again, that consistency with our Division 2 process and the hearings standardization, so that's why that one is struck. And consistency with protests and all of those things. And then the final one is 1200. This goes back to the change that we made around land use in the Division 380 rules. This is the same change. As we acknowledged, we're continuing to talk about land use issues. So I don't have a full resolution on that, but that is, again, the same rule as what you saw previously. So that's 382. Other questions, comments? We can go back to any rule on the list, because I know I zoomed through that in my own mind. At the same time, I know you've already seen all this and commented on a lot of similar things, so. Okay, so we are going to take a break before we start on Division 77. Thank you all. I appreciate the comments this morning. I appreciate the good discussion around workload here for all of you. So we will reconvene shortly.
we're gonna get settled in.
But there's still that opportunity. Breathing the guy, yeah. Awesome.
Okay, so you all hopefully got a good little break in there. We're switching gears. I guess before we switch gears, is there anybody from the public that wanted to comment on 382? Because I know that our brains are gonna move off of 382 and on to 77. Okay, I'm not seeing anyone. Just know we'll have I think how we're gonna manage the public comment today is, since we just wrapped up 382, I wanted to make sure that we had that opportunity. We will be working through Division 77. So any comment on 77 will occur then in the next period of time. Which is when the RAC, because the RAC is gonna get through 77 today, I know it, so we will then, have public comment at the end of that next one. If you cannot make the public comment that we next open up and you wanted to comment on 77, you're always welcome to provide written comment. As a reminder, this time is, prioritized for the RAC membership at this point in time, so that's how we will manage that. Thank you to Laura for flagging that for me this morning. So I had not thought that far ahead, honestly, because we're a little tired, right? I also, before we get started, I see Ivan is looking down, working on his phone here, and so that's the perfect time to call on the director, but I just wanted to note that the director is here, and Ivan, do you want to provide any comments to the RAC, since you're here, or should I keep moving along on Division 77? Since I'm putting you on the spot, you can pass.
Well, I'll just quickly thank you all again. I know this is a big lift. Everybody's busy, and is moving very, very quickly on this, so I appreciate everybody's time and consideration. My instructions to staff have been to move through this process as efficiently as we can. We're trying to meet the statutory go live deadline there of April 1st next year. This marks the biggest update to rules I think the agency's ever done. So again, I appreciate your participation in it. And any thoughts you have on process improvement, other than slowing down, would be greatly appreciated. So thank you.
Great. So Division 77. I was enjoying that moment where I wasn't doing the talking, and I just realized I need to talk again. So give me a second to get my notes here up. All right, so Division 77. I need to get to the rules. Sorry about that. Okay, so this first one, 4 O's, that one. The purpose. So we have added a provision in here, which is, we think provides clarity as to what the law is already. But we know that sometimes there's concerns that arise out of this, so this is us trying to proactively address the concern that we've heard. And so you'll see number 7 there is, and we may need to massage the language, so see, looks like, I know someone's ready to go here, but this is about in-stream water rights leases, transfers, and ACW. We can only protect that water within the state's borders, and so we consider within the state's borders to be, yes, the Columbia is within our borders, by the way, so if we had one there, Snake is within our borders, so those ones that form the border is part of the border, if that makes sense. That was my question on this one last week when I was reviewing these rules. So That is, and the rationale there is we can't go protect an in-stream water rights that's in the state of Idaho, right? That whole water right is in Idaho. So,
Are there any state,
yes,
are there any state compacts that would override, would include an in-stream water right for both states?
I don't,
Or is there a
No.
potential for a future compact that would, include a in-stream water right where it is a protected stream right because of the compact?
in that case, the compact would override this, right? So,
Like
Um,
Kimberly's thing.
yeah, but so in our, so this is really about the where the water rights are protected. So we can protect it to our borders, right? But we can't go and regulate an in-stream water right in California, right? And remember, an in-stream right is one that's in the stream
Right.
or in the lake, right? It's not, finding in-stream provision. Oh, I thought we had a. In-stream means within the natural stream channel or lake bed or place where water naturally flows or occurs, right? So this, we can only protect to the border, and then we've got our landowner states. So, Kimberly?
Yeah, I think it might just, the language might need to be massaged to Glenn's point. I mean, I'm thinking of, for instance, the Walla Walla, where my understanding is the state of Oregon is talking with the state of Washington to try and protect the water that farmers are putting in stream in Oregon through Washington. And so we just want to be careful that we don't somehow indicate. I think what you're saying is the state of Oregon can only,
This
and
is
maybe,
the
yeah,
state of
so maybe that's the
Oregon, right?
distinction.
So like,
Yeah,
our authority goes to the border,
yeah.
then Washington has to take over. They would need to protect it, and then when it comes back in,
Mhm.
right, we would need to. So that's the, but if you all have language to make this clear, feel free to let us know, because I do want to point this out, but this is an issue that's been a confusion, particularly in the Klamath Basin, so, so if there's thoughts on this, we're trying to proactively clarify this provision. Okay, James.
Thanks, Raquel. James Fraser from Trout Unlimited. I had a similar comment to both of the ones that you just had in the room, and I got similarly stuck on this related to the Walla 2050 plan, because my understanding is that, yes, WRD is only protecting that water in stream to the state border, but fully intending and expecting the state of Washington to then protect that water down to the Columbia. So I think the way that this could be restructured is to clarify that WRD will only protect water in stream within the state's borders under an in-stream water right, in-stream lease, and in-stream transfer, which is more narrow and specific than saying basically we're not going to allow deals if they are intended to somehow protect water in stream outside of Oregon, which is what I think it says right now.
Okay, so I will look forward to, I'm hearing that we need to fix this. So I'll look forward to, we will work on it, but if you all have thoughts on specific language, if you could include those in your comments, that would be helpful so we can make sure we get this right.
And I also just would flag that today's RAC overlaps with the OWEB meeting where they're talking about water acquisition. So I know that some people are going back and forth. Anton Kiono from the Umatilla tribe specifically is not here in this meeting right now, but this specifically might be one where he has thoughts too. Thanks.
Yeah, I'm seeing my note taker drinking water vigorously here. Can you make a note to follow up with Chris Coates and Anton, just in the context of the wall? Thank you. Thank you for that flag. I did not know that, so I appreciate that. It looks like other folks knew that, but okay. So we're gonna go to 10, definitions. And the one I wanted to point out for you all, I think all of these ones are what you would anticipate to see. But the beneficial use one is just the consistency. We're making them all consistent with 300, so we don't have definitions all over the place. One day, it's not this rulemaking, by the way. I'm gonna do a mega definition rulemaking. Because I just cannot stand how many definitions we have. But that's not for today. So we're doing our best with the time constraints we have, but one day, just know that will be coming. ENAF is the one I did want to note that we clarify, because I know folks are always interested in ENAF, which is EANF, even though in my head it's ENAF, which doesn't make sense, but estimated average natural flow, that's number 12. And we're clarifying what we basically already do, which is that it's by month or half month. So that is the clarity piece. Okay, let me see what other one I had. And Kimberly, I see you. I just also will note that we've added one related to, or we modified the water purveyors one to be more specific. I don't know if Mark Landauer is on right now. Oh, he is. And I do know that. Sorry, I've got a list here. But Mark and Michael, I'll just flag that one, as well as 35 is one that I'll discuss in a second here. Kimberly, why don't you go ahead on
My comments on 35.
Oh, okay, so let me get to 35 then. So where did 35 come from? So Mark, are you on?
Yes.
Okay, so. There you are. So last year, we, I think it was last year, it could have been 2 years ago, sometime within the last 2 years. The Special Districts Association had reached out to us with concerns about some of the entities not being notified up front about the application for new in-stream water rates. So we have a practice of
Notifying cities and counties. And the Oregon Department of Fish and Wildlife is not required to provide notice to anybody beyond cities and counties. And needless to say, that's a problem, because there are plenty of other water users, districts involved with water management that need to be aware and notified of these applications. And so the purpose really of this is to ensure that the breadth of water users and districts that manage water in some way or another are notified of these in-stream water applications. Hope that explains the purpose of this.
So, this is something that we worked with ODFW. I see Danette is on. And Spencer, who's not on, but we worked with ODFW on this. And so ODFW, and we agreed that ODFW would notify these special districts. We set out a process though that SDAO, so you'll see this later on in the rules, that SDAO needs to provide us with a list. There's a lot of special district types out there, right? And so we've come up with a process that is, I think, efficient. So we've been doing that process, and we told the special districts that we would bring this forward to the RAC for discussion when we get back to Division 77. So we are here. And so that's what that is about. I will point it out. This is just the definition, right? this is not actually the provision, so I'll point it out when we get to the actual provision later on in the rules. So with that, I'll note Chris.
Yeah, it's more like a question, I think, and it's not even about something that's been proposed for a change, but the definition for in-stream and in-stream flow, which are proposed to be renumbered as 14 and 15. During the time when the IWRS was being updated, there were discussions about what does in-stream mean. And I was told that the part that says, or place where water naturally flows or occurs includes groundwater. So, and in fact, I have the IWRS up here. I have like notes from OWRD staff to this, if you'd like me to provide them. Out of stream means water withdrawn or diverted from a groundwater or surface water source for beneficial use. So the thing that Water Leak had brought up for quite some time was in stream and out of stream. Does that mean in ground and out of ground? Right? And should we be, because groundwater is so important in this state, when we do this whole IWRS, shouldn't we be like referring to in ground and out of ground? So the response that came back from OWRD was, well, in statute, we interpret a place where water flows or occurs naturally to be in ground. And of course, that seems to make sense because here in this little box in the newly adopted IWRS for 2025, it then follows up with the out of stream definition, which is water withdrawn or diverted from a groundwater or surface water source for beneficial use. And so I was just questioning whether in-stream and in-stream flow want to be in rule, the definition wants to be elaborated on or not for that purpose, because I could see how hydraulically connected groundwater in many instances throughout these rules might impact the way in-stream flow or in-stream is, managed. And again, this is a question not to be resolved here, but just to ask you to consider.
So, I will respond and then we'll see if we get head nods in a yes or no manner. So I would be interested to see the emails that you referenced. Because I'd like to see if it was clearly referencing the statute or if this is about how we more generally talk about in stream and out of stream as it pertains to communications type of documents such as the IWRS. My understanding today is that the in-stream water rights and how we administer that is that it is surface water rights. And so I'm getting head nods, yeses. This is always a quiz for me in these rooms to see if I retained information. So, I think we would need to look at that to see more specifically what was being discussed, but I don't think we are to date issuing groundwater rights under this provision under 537-332 to 360. There is a different history on the conserved water statute, so I just want to note that. I know we discussed that. We will bring that one back in all likelihood for a discussion as to how that one came about. That is different than what we're talking about here. And I'm getting thumbs up, so thank you, Chris, for that question.
Yep, I think their comments actually, that's responses from staff to Waterlee's comments. And so I'll dig them up.
Okay, great.
Yeah.
Thank you. Kimberly.
Yeah, I guess my question to you is, we do have concerns about expanding the notice to special districts and the way it's being proposed, as well as existing notice requirements. So do you want me to hold those until we get to that section?
Yeah, let's let's talk about that when we get to this section. So then we have the actual text of what we're doing in front of us, because this right now is just the definition of who that provision's referencing. Thank you, Kimberly, for asking that question. Okay. So we are going to move then to, not seeing any other hands. 15. Oh no, I put all of this in green. Green, by the way, means that I feel like we need to talk about the whole thing, so. So, let me see why. So this rule is amended to remove language that's not consistent with statute. Oh, so this is about ENAP. Okay, so this is about new water right applications. Just to be clear, we're in that section. Later, we'll talk about leases and transfers. We're not there yet because it's different. So, oh, maybe I'm getting off track here. This one is about, yeah, okay. Oh, so, I see, this is the general statements. My apologies, folks, I'm confused. So, this one is removing language that is not consistent as it pertains to transfers, leases. I didn't realize they were all mushed into one section, that was my bad, so. So it retains the language related to ENAP as far as new water rate applications, but it's removing the language as it pertains to transfers, leases, ACW. And so this is in part because there's statutory authority where we can do this for new water rate applications and determine the flow amount. For transfers, leases, and ACW, we don't see that same provision and the justification in the statute for that. This was an issue that has been brought up many times, right, over the years. So this was one of the questions I believe that arose in the last Division 77 RAC, so that's why it's here. So specifically, why do we think that it's different? So 537.343 provides the department with authority to make the final determination of the level of in-stream flow necessary to protect the public uses for an new in-stream water right application. Okay, so we can make that determination of the flow. And this is the basis, right, that we're doing to determine that flow. So we want to have a clear standard for us to be able to hit the target. We haven't identified that similar basis for transfers, leases, etc., right? So this is really clarifying that particular provision. And the other piece to this that it is clarifying is in 8, which pertains to withdrawals. So the withdrawals piece, it's making clear that any withdrawal rule or order, right? So it's trying to clarify this language that's in 8 that's that I think folks are trying to understand what it exactly means, because classifications are one thing and then we have withdrawals, which are different. So any withdrawal rule or order does not withdraw a natural lake or stream for in-stream public uses unless the rule or order specifically states that it's prohibiting the in-stream public use, or the withdrawal is for the exclusive use of a municipality. Exclusive, from our standpoint, is what we believe is similar, right? That it's saying it's for this particular use. I want to be clear that, again, these rules apply to new applications. They don't apply to any that are existing applications that are pending. So with that, I see there's comments. Kimberly and then Glenn.
First of all, as far as removing the ENAF requirement from transfers and leases, we agree with your analysis that there's no statutory authority for that. So I think that's consistent with the purpose of this rulemaking to align rule with statute. That said, we don't agree with your analysis that ENAF applies to new in-stream water rights. The statute does allow the state to either condition or reduce or reject the flows applied for by ODF and W, but they can only do that in instances where the reduction is consistent with the intent of 537.332 to 537.360. So there are boundaries there. And then when you look at those subsections, having a sort of artificial cutoff that is a blanket cutoff for all applications, not, application specific, we would argue is not at all aligned with the intent of the in-stream water rights. And so this is something we have raised for years, and we will continue to raise that. We think this provision of rule as it stands today, and then the clarification here, is not supported by statute, is invalid. So, and then also, I guess, maybe I said this, but the department is supposed to make findings on any application where they do reduce the flow. It's supposed to be a finding specific to that application, why it's consistent with statute, et cetera. And this sort of blanket flavor doesn't ascribe to that. So. And I'll submit written comments. So it's,
Yeah, I was just gonna
Yeah.
ask that when
Yeah.
gets,
Yeah.
it would be helpful to have the specific
Yeah.
thoughts on that. Katie?
Yeah, so Kimberly, I know you're very familiar with these statutes, but just for everybody's context, we're referring to 537.343 here. The language saying the director shall be the final authority in determining the level of in-stream flow necessary to protect the public use. So I recognize that Water Watch doesn't agree with the way that we're reading that, but I just wanted everyone to know that that's the statute we're talking about. And then also just to point out here, that under sub 4, so we're in 0015, general statement sub 4. So there is the ability for going over ENAF in certain cases. And again, Kimberly, I know you're very aware of this, but for the benefit of everybody. So the limitation is ENAF, except where periodic flows that exceed the natural flow or level are significant for the applied public use. An example of such an exception would be high flow events that allow for fish passage or migration over obstacles. So it doesn't, I'm not really aware of the problem that we're trying to solve, because there is this ability to go over ENAF if it's justifiable.
yeah, and I guess to the 2 points, I would say, yes, there is that provision in statute that allows the director to make the ultimate determination, but that has to be read in the context of the statute as a whole. And in the other section that I noted, the director does have to have any reduction or denial has to be consistent with the in-stream water, right? So it's not, the director doesn't just have sort of willy-nilly authority to reduce flows to whatever he or she wants. It is within the construct of the in-stream water rights act. And I do appreciate your point, pointing out that section that does allow the department to issue over ENAF in particular instances. And I think that was added, I believe, in the last rulemaking on this as sort of a compromise. But I will point out that in practice, the department is still limiting everything to ENAF. And we would say all applications we are seeing are still being limited to ENAF. And we would say, ODF and W is the state agency. They are, that are experts in what fish need. And so we would say every application meets that standard, but that's not how the department's interpreting it. So long story short, I appreciate that language is in rule, but on the ground, we're still seeing the same problem. And so our position, again, I'll get it to you in writing, but our position is that the statute really doesn't allow this kind of blanket reduction.
Kimberly, can you, I don't know if Bryn caught it, can you put and Laura, but can you get what's the statute that you're saying? Did you say that?
So
If not, you can
it
just
has
get it
to-
in writing. but
yeah, I'll get it to you in writing, but it has to be consistent with the intent.
What is the citation? Do you have the statutory citation?
537-332 to 537-360, and the statute that directs that is 537-3431.
3431. Okay.
I'll get you this. Yeah, I'll give you this. Thank you.
Okay, Glenn.
On 8.
Yeah.
or 8, this might be a kind of unintended consequence, that it was a comment written for me here, so. The future problem with this, that it seems plausible that you could have withdrawal for all uses except for what was spelled out. This rule would mean that in-stream water rights would still be allowed, even if it wasn't among the exceptions listed. It may seem like this rule should go in an opposite direction and say something like natural lakes and streams in this state shall be considered classified to allow in-stream public uses unless the natural lake or stream is withdrawn from appropriation and is no longer, or it's no specific exception for in-stream uses.
So, thank you for that. So I want to walk us through a little bit of water right tools here. So the department and commission have classifications. Okay, classifications are the uses that we are allowed to issue new water rights for, right? You can get an exception to that, but we're not gonna go there. So there's classifications. That is a different tool than withdrawals, which is why this rule is confusing to us at best. And so they're merging two concepts together, right? And so the withdrawal statutes are a separate tool, right? When this, from our perspective, when these rules were adopted, this was intended to address the fact that in-stream uses weren't classified, right, or acknowledged, because there wasn't a tool at the time, right? Then we had the In-Stream Water Rights Act. And so this was saying, hey, this is, these are allowed uses, right? So so if we say all natural lakes and streams in the state shall be considered classified to allow in-stream public uses, right? So that's addressing that fact that that wasn't a consideration, right, when all these things were done. And then it says, unless specifically withdrawn from appropriation for such use. Well, for such use, right? So unless it's withdrawn for the specifically in-stream public use. So the withdrawn, that is why we're specifying this, is because we're reading that and we're saying, well, what they really meant is that unless it's, there's an explicit withdrawal saying you can't use it for this use. And that's why we think the exclusive use of a municipality is one of those areas where that to us, because it says exclusive, that seems like it's specifically withdrawn from that in-stream public use. But much like other, much like the classifications, the withdrawals, right? Because in-stream wasn't the thing, right, that we were considering. We think this is more in alignment with the intent of what this rule says. So, and again, this applies to applications going forward, not pending ones. So that's how we got there.
Now, it's just, I think what the comment was made to help clarify that you weren't exempting all of their uses just for this. So I'll just throw that out there.
Okay. Can you maybe get that to us in writing, just so I can, I'm not sure I'm fully processing it.
Okay.
If that would be, unless. I think it would be helpful if you can like give us your specific notes so we can think through it. Thank you. James?
Thanks, James Fraser from TU. I would just say Trout Unlimited agrees with everything that Kimberly said about ENAF. In order to save time, I won't give the reasoning. I think she said it well. And I'll say that for now. Thanks.
Thank you, James. Jeremy, and then Chris.
Great, thanks. Jeremy with Central Oregon Land Watch. Yeah, similar questions around ENAF and something that I was thinking about just to add to the room is not only the application of ENAF here, but also the exception of periodic flows. I'm thinking about streams where just even within a day, you have a fluctuation in stream flow of anywhere of 10 to 20% around the daily average. And so setting an average really fails to encompass the flows necessarily to support like ecological process on any given stretch of stream. Thanks.
Okay. Chris.
Yeah, seconding Jeremy, James on Kimberly. My question is, well, first I'll say that sometimes the average doesn't really represent reality, or a lot of times like we'll have a set and then we'll go to the average and say, there it is. That's like what we should follow. But a lot of times that average actually doesn't represent what's important. So I think this is a good example where the average is not representing what's important. So it's maybe not the best thing to peg to. And then, in this regarding the ENAF, and then I had just a question. I was looking at obviously chapter 537.343 subsection 2, where the director shall be the final authority in determining the level of in-stream flow necessary to protect the public use. This is a general comment that, and we talked about like we want to streamline stuff, we want to keep it simple. That's what this is all about. Well, the statutes are really clear, I think. And we got 55 pages of rules and for the statutes. I mean, the elaboration on the statutes is, I'm sure there are many other examples where the elaboration is like order of magnitude bigger. And that's not quite what we're seeing here, but it's still pretty big. Why can't something simple as the director shall be the final authority in determining the level of in-stream flow necessary to protect public use? Why can't that just suffice for number 4 instead of getting into this, which is really, it's been here for I don't know however long this rule's been in place. Why not just strike it and just rely on the director to follow that statute? Because what is it? Keep it simple, silly. That's my thought, is we could just keep it simple and not get into this elaborate thing about, well, is the average and, well, what about the same and jumping over the dam? They need extra water, and it just gets overcomplicated. And I'm sure the director would go to ODF and W and be like, hey, guys or girls, what do I need to make this in-stream water right work? Because I don't understand fish, you guys do, so you girls do, so.
Well, they're the ones applying. We don't apply for them. So
Correct.
remember yeah.
But when the director's making their decision to know better than ODF and W perhaps, so there was obviously back and forth, so those are my thoughts. Thanks so much.
Okay. So we've got those noted. And we'll take a look at this. I think, the important thing for us to be in-stream water rights are the number 1 most protested type of water right transaction. And we did have discussions around this, and one of the things that is important to us is to have a clear replicable, is that a word? Did I make that up?
Replicable.
I don't know why I can't say that word. She's gonna say it for me. A clear, thank you. Where we have a standard that is, consistent, defensible, because a lot of these are protested at the end of the day. So what I'll encourage folks to just think about is, I think so I hear the language, Chris, that you're noting on the statute. And then I also know the reality that we have, which is that these are always They're not always contested. I should be careful. They are often contested, right? And so trying to be able to have a very clear, here's the methodology and approach, right, is really what we're trying to do here. Maybe this isn't the right one. So, you know, if you all have thoughts on that, please feel free to submit those to us for us to consider and then talk with ODFW on them. But that is certainly just one of the things that's on our mind, is trying to make sure that we can effectively issue these, right? And if they're sitting in our protest backlog for decades because there's so many protests, then they're also not getting the protection that they warrant as well. So we've got that challenge there. So I'll go to Chris. It sounds like you have a follow-up, and then we're gonna go to Greg.
Yeah, brief follow-up. So, you know, after the contested case and the Office of Administrative Hearing hands down a proposed order, the director can still do what they want. Is that correct? Do I understand that?
Correct, yes.
So regardless of the protests and how many times they protest all this stuff, I get back to this, you know, unitary executive who can essentially do what they think is right, even after a contested case. And so, unless I'm not understanding something, I'm not yet moved by this idea that we have these protests. We're gonna have these protests for sure, but, in the end, the statute says both in contested cases that the director can do what they want after the hearing is over. And it says here also with the proposed final order, they can do the same. So I just,
So I'll say, I want to be careful about we can't just do whatever we want for the record, right? We still have to meet the evidentiary standards, right?
Yeah.
So ponderance of evidence, we've talked about that. And it can then it can then go to Court of Appeals if it's gone through contested case. So there is still it's not the final stop in the road, right?
Mhm.
Potentially, if there's disagreement. I appreciate what you're saying. Again, if you all have thoughts, we are trying to look at this from the standpoint of effective administration as well. So
Sure, one thought.
yes, and then we're gonna go to Greg.
Okay,
Yeah.
sorry. So, thanks, Greg. Just, when we have more detail in the rules, it's not only, it helps us be more consistent in our processing and provides guidance to staff. We strive to be consistent, and then it also just provides transparency.
Yeah, clarity on what staff are supposed to be doing, clarity to the public on what we're going to do, right? And Greg, I apologize, I will get to in 1 second. I do also want to acknowledge this idea that agency cannot, we cannot do, remember that definition and how it's 2 weeks or a month, right, is the flows. We can't be expected to manage an in-stream water right minute by minute, 24-hour by 24-hour period, right? So it is when it comes to administration on the ground, we do need a little bit of stability there. We totally understand hydrology and that there are, every year is a different year, right? So that's another just comment on the averages piece and we have to have some kind of flow set, because that's the only way we can actually effectively manage it. And we've got to have a time period with that, so the water masters can also effectively do that work. Greg.
Yeah, hi, thanks. So all this discussion about flows, it occurs to me that maybe I know it'd help me, but it would probably help the rest of this committee to understand, I guess, really where those come from. I guess my understanding is that, if ODF and W is applying for in-stream water rights, they're basically looking at, and I could be wrong about this, but they're looking at, I think they come in and they kind of ask for what they think they need. And then the department looks at that and says, well, they look at the WAB data at 50% exceedance to see, well, do we have that much water available? And they'll basically issue, as I understand it, everything all the way up to what ODF and W is asking, or to whatever is left, basically, based on the WAB data. And so often these in-stream water rights are issued for less than what ODFMW is asking for, because the department, I guess, normally doesn't think they can issue in-stream water rights that would end up exceeding what water is available. Now, I mean, I could be wrong, but that's my understanding of how it works. Can you either confirm that or explain for our benefit, how does they come up with, where do these numbers come from?
Greg, thank you for that question. So, Danette, I'm just gonna put you on deck here, just, because I see you're on, and I'm gonna first ask Katie the question, and then I'm gonna see if Danette wants to clarify anything, or, I want to so we do have ODFW here, so I want to make sure that we give Danette an opportunity. So Katie, do you want to explain from the WRD perspective, and then Danette, if you're willing to do any cleanup / ODFW perspective, that would be awesome. So, and thank you, Danette, for being here and listening. Danette has, by the way, been, we had sent her over many of the rules, and like 1 week she turned them around in like 5 seconds and like had all this like feedback for us, and I was shocked, amazed, and just so impressed. So thank you, Danette, for your work and for helping us on our ends here. So Katie.
Okay, I want to pull up a document, so that's gonna take me a moment, where we explained in testimony how we derive estimated average natural flow, because I want to use my words precisely, because again, we get taken to contested case on this again and again and again. So I want to make sure I get that language exactly precise. If it's okay to take a moment to find that.
Okay, let me go then to Danette. Do you have any, Katie's doing some looking. Do you have any comments that you would like to say for the good of the group here?
Yeah, sure. Thanks, Raquel. Danette Facera, Water Policy Coordinator with Fish and Wildlife. I think a lot of the discrepancy between our recommended flows that are in our applications and ENAF comes from just being two different models that they're based on. No two models are ever equal. And our model is a habitat-based model looking at the entirety of habitat that could be provided by the stream system or the reach that we're applying for. So that can often be different than ENAF, which is half-month or monthly values. And it does somewhat capture the natural hydrograph going up and down within the season. So I think it's a model discrepancy, if that helps kind of explain it at high level.
Thank you, Danette. Okay, it looks like Katie is ready, and it looks like, are you reading from a
Contested case hearing testimony?
Oh my goodness, so this is gonna be super interesting.
It is, all of it is. That's why we're here. And it also recognizes that we say ENAF, but it's also EANF. So anyway, he's enjoying that in his testimony, but, so he says, ENAF,
And who wrote this?
this is someone giving testimony from our surface water hydrology group.
Is this something we can share after the excerpt
I think
to
so.
make it easier so people aren't frantic?
Yeah, I can double check, but I think so, if y'all can make a note of that. So ENAF is meant to represent prehistoric stream flow, and is the flow in a stream when there are no consumptive uses and there's no flow regulation by dams or reservoirs. From ENAF, I subtract existing reservoir storage, out of stream consumptive uses, and in-stream demands to calculate water availability. So he's describing here also the difference between ENAF and water availability. So he goes on and says, the amount allowed for perforation of an in-stream water right shall not exceed ENAF as defined in, we're talking about 0015 here, Division 77. The department's standard representation of ENAF as it relates to evaluating in-stream water right applications is the 50% exceeding stream flow or the stream flow that occurs at least 50% of the time. So that's getting to Greg's point. But I wanted to add in the nuance there of looking at kind of the conditions before things have been taken out of the stream by consumptive uses and storage.
Okay, so we will, sounds like we think we can distribute that. I suspect we can, so we will get that out to you all, for those of you that are curious. I will tell you, I actually was more entertained by that than I thought I would be, because it used the term prehistoric, which made me think of dinosaurs. But I know that's not what they meant, but that's what I thought of, so, okay. So we will get that out to you all, and, you know, I know this is a detailed topic, so, I think it is helpful on this one to have, you know, specific comments to the extent in writing. We are capturing what you have here, but I know this is important to everybody involved. So if you have specific recommendations, feel free to note those to us. Okay,
We'll follow up.
Greg and then Chris.
Oh, I'm still on here. Okay. Yeah, I just wanted to, I guess, mention that, I mean, I think the reason that a lot of these in-stream water rights are contested is because the ramifications, or there are a lot of ramifications to establishing these in-stream water rights, especially when you consider that, you know, they have a big impact on water availability for, you know, that comes under consideration when somebody's applying for a new water right, either a groundwater right or surface water right, wherever that's possible. So I don't know. I don't know if we can have any kind of discussion about that, but I just think it's important for everybody to understand that there are a lot of big ramifications associated with, you know, establishing these in-stream water rights. That's why they're often contested. Just wanted to mention that. Thanks.
Thank you, Greg. So I want to note that establishing in-stream water rates is a priority for the state of Oregon. Okay, so and I also want to note that there's also big implications to not establishing in-stream water rates, right? So I think that in terms of that policy discussion, in terms of whether we should or should not have them, I'm just going to note that the state's weighted on that, and it's in the integrated water resources strategy. It's in the department's mission. So, and Greg, I don't know that that's exactly what you were saying, by the way. So I just want to note that I'm not trying to put words in your mouth, but I just want everyone in this room to know that this is something that we see as an agency is important the executive branch. So, with that, Chris, anything to add here?
Yeah, first, there's always two sides to something, right? Actually, the ramifications started when the state over appropriated groundwater and surface water sources on every basin. And so the in-stream water rights were actually established because of the extraordinary ramifications of water use for humans. And so when we want to talk about ramifications, let's be clear that the ramifications started when we were turning creeks and streams into gravel roads by midsummer and causing excessive unreasonable declines in groundwater across the state that would otherwise provide base flows into these rivers. So the ramifications of not having that. So the protests against in-stream water rights are really just pushback from water users who have already been impacting the water sources to the extent that the state decided they needed in 1987 to create in-stream water rights. My question from previous was, we have the ODF&W model, and we have the ENF model that Water Resources Department uses. And I get the impression that they don't necessarily align. And which model is more appropriate? You know, if ODF&W, they're the professionals who understand stream flow for fish and wildlife. Does OWRD want to just defer to their model, their, sister agency? Or does ODF and or does the Water Resource Department want to take this like hydrologic model that doesn't really follow the ODF and W concerns and just say no? And so I just wonder whether or not those models want to collaborate or be a little bit more.
So I think it's a fair question that I'm not gonna answer today, right? Because I've heard all the comments. I appreciated Danette's comments, because that also gave me some things to think about as well. So I think it's a fair question that I'm gonna put as a question for us to, as part of our thinking about all the feedback that we've gotten, as opposed to what's WRD's position on this right now, if that's fair.
A lot of these comments I have are just like questions.
Yeah.
Okay.
Thank you. Okay. We're going to move to 19, which is a provision that was, I believe, deleted in the 2025 legislation. So I'm not gonna do any hard thinking on that one. That last rule was a good one. Okay. So see, folks are looking. As we move into 20. So 20, I did have a few items I wanted to flag for folks here. So there are some components that are as a result of the 2025 legislation and some of the clarity that we were trying to establish through this rulemaking. It also gets at the electronic documentation, the phase processing. There is an in-stream specific map. So I'll just note that that one's a little different. And then there is the two items that I think you all are probably interested in, which is number 3, and then K, I think it's K, which is K is the 3 and K are the ones that are related to the special districts discussion that we started. So that's the specific language that we started discussing. So I know there were some folks that wanted to comment on that one again. So I will pause there. And Kimberly?
Yeah, I will just start by saying the In-Stream Water Rights Act does say that processing of in-stream water right applications has to be aligned with processing of out-of-stream applications. That's in 537-349. There is nothing in the statute that requires or allows advance notice to anyone. So not only to the special districts, but also in J, which is affected local governments also get a free application notice. And so this is something that we see as unfair and inequitable. And we think that the department should provide the same notice of in-stream water rights as they do for regular water rights. And so if you look at 310, I believe, the way, I don't have it in front of me right now, but basically under 310, when there's an application by a water right user, which again, in-stream water rights are supposed to follow the same process. The department does give notice to state, federal, local governments and tribes at the IFR stage. And so I think we would recommend that the notice provisions to be aligned with statute and also provisions for out of stream, that you should change it to do it that way.
I'm gonna look to James, I see you. I'm gonna look to Danette just briefly. And Danette, you are allowed to decline, so just note that you are under no obligation to respond here.
I think if I'm remembering, when we've had so Kimberly, I agree. I also, think that some of the notice and coordination up front allows for conversations that I think we think may reduce the likelihood of a protest because there's some coordination and understanding up front. And so we may see some benefits. And okay, before I go to Danette, Kimberly is waving the flag.
No,
Do you have a response to that?
I'll
Okay.
respond after
Okay.
tonight, but I do have a response.
So Danette, do you have anything to add? You can also say, Raquel, I don't agree. That's totally fine too. Or you can say pass, because I don't want to put you on the spot unnecessarily. We will be following just so you all know, we will be following up with ODFW and DEQ, our partner agencies, after this to talk more about Division 77. So this isn't going to be a vacuum here. So we appreciate Danette. Do we have someone from DEQ on today too?
Thanks.
Okay, so I'm giving all this attention to Danette, so I just want to make sure I'm being fair to our other sister agency, but Danette, do you have anything you want to note or?
On what specifically, Raquel? Can you?
Just on the pre-application notice.
For affected local governments and special districts, I will tell you that particularly for the affected local governments, which we started with until recently, identifying who to notify and finding those specific contacts either on a website or by calling is very challenging, and it takes a lot of time for us to do. Oftentimes we send letters to Public Works or other departments. Sometimes those are returned, sometimes they don't get to the right people. It's a tedious process to identify those entities. Working with Mark and SDAO, they have those lists for those they want identified. So that's been a fairly easy process, maybe kind of going back and forth with our agreement with them to provide a list, and then they give us the specific contact. So it's just sending out the email to them. Doesn't take a lot more time, but what that often leads to can be confusion about how our in-stream water rights will or will not affect those entities. And it often leads to a lot of correspondence with us. Sometimes it may resolve a protest, usually not. The hopes is that we can reach a settlement maybe with those entities if they are considering a protest. I think the new Division 2 rules will also give that flexibility to discuss those settlements prior to referring to contested case. So I'm still not really clear in my head how they all overlap with Division 2 and the timelines in there for settlement.
Thank you, Danette.
Yeah.
Great.
I don't know if that answered your question, but.
No, it's great. And like you said, you don't feel obligated if I call on you. So,
and I guess I'll just add one more thing that, we don't have anything to hide from anybody. We do want to be transparent, but it also can cause confusion and a lot more work, I think, for a lot of folks.
James, do you mind holding for a second? Because I think Kimberly has a response.
Sure.
And then okay, I know you've been in the queue. Go ahead, Kimberly.
Yeah, I guess I just want to respond mostly to what you were saying about these advanced conversations. And I would say it's much different. If people want to talk to ODF&W is very transparent and they will talk to people. It's a much different thing to put it in rule. By putting it in rule, you're setting up a state agency for challenges in the future if they are somehow unable to contact the right person. So I think, again, in order to be consistent with statute, any provisions on advance notice should be removed. So I appreciate your point, but
No,
again,
I appreciate your point.
Yeah.
I appreciate your point too, Kimberly. So I actually have a response to that. Because when we were first discussing this, I think Mark got an email from me saying, nothing in this informal process agreement shall allow you to, protest because this was not fulfilled, right? If someone was missed. So what I wonder is if that is potentially needs to go somewhere in here, that this is a courtesy notice, but it doesn't procedurally result in I'm not a lawyer. I don't know what the wording is, but there's a wording that probably is
Yeah.
correct for this. So go ahead.
Yeah, I would say, again, we do not think it's appropriate to put this in here, even if it's a courtesy notice. I'm pretty sure you would hear similar comments if we struck a deal with the department to get advance notice of, every damn application that was coming through. I mean, it's just creating sort of a special class of water user that gets a special, differential treatment as compared to other people. And we just don't think that's fair. And, to your point about having conversations, again, I said anyone can have a conversation with ODF and W at any time about what they're planning on doing. They are very open and transparent. But by, in addition to the points Danette made, I will also say what we're saying is, it also opens the door to political pressure. If people get advance notice in advance of applications being submitted, they can go to their county commissioners, to their legislators, who can then put pressure on the agency to hold off on submitting. And I just think that goes against, so many principles that the state is moving forward with, including principles, in the integrated water resources strategy, all kinds of documents about moving forward with stream flow restoration. So.
Okay. Thank you. The director came in at the perfect time, so he can hear the discussion. It sounds like this is one we'll have to bring back to the group. James.
Thank you. James Fraser with Trout Unlimited. Raquel, your overview of the SDAO provisions at the beginning of this division meeting was helpful. And what I heard is that these provisions are neither provided for in the 2025 legislation or otherwise a cleanup. So as a result, TU's position is that they simply shouldn't be in here. I'll add, though, that I can't think of another administrative rule that writes an NGO into the law, which these rules are, and then provides for special notifications and communication rights to that organization with accompanying burdens for an agency. We have a public notice system for water rights information that everyone here knows how to use. And frankly, we all have the annoyance or burden of looking at that thing for things that concern us. ODFW has already been going above and beyond existing law in the past year or so to provide public meetings and heads up about these types of filings. We disagree with this language and all of the other SDAO provisions in Division 77. So I think this needs a lot more work and really should be removed. I will lastly say, though, that the word only in the last sentence here should be deleted if the concept is going to remain. It basically sets a trap. And I'm not saying what, WRD has with bad intention set a trap, but there is a trap here where ODFW might go through all of these special communications with the NGO only to violate a requirement that they shall notify only potentially affected entities. If we're going to have this in here and the organization and the agency have determined potentially affected agencies, it should just say that ODFW should contact them, not that they shall contact only, because that's unnecessary. Thank you.
Thank you, James. I appreciate you helping us make the language better should it stay in, while you're also letting us know that you would like it out. So thank you for both of those comments. And I see that Mark would like to. Oh, okay. I'm missing folks in the room.
Go.
Well, Glenn's also been, I don't know who's been first. Sorry, Glenn, you're on my periphery here. Next time, just wave.
Throw something.
Okay, let's go to Glenn and then we'll go to Mark and then we'll go to Chris.
I just would echo what you've already heard, that I don't like it spelling out an NGO in the rules. And
okay.
that we should come with some different type of language if you're trying to expand who gets notice.
Okay, thank you. Mark?
Yeah, I'd just say that, there's a bigger question, and I understand where Kimberly is coming from about nothing in the statute requires a pre-notification of an application for in-stream water rights. However, the fact of the matter is that the Oregon Department of Fish and Wildlife has routinely provided pre-notice to cities and counties. And the purpose by which we're trying to add special districts is simply, if it's good for the goose, it's good for the gander. Now, having said that, we are forms of local governments, just like cities and counties are. We should not be treated any differently than the cities and counties on this topic. Whether or not that pre-notification should be written into the rules is a separate conversation from whether or not special districts should be treated the same way as cities and counties. So I just want to make that point. So if the group decides ultimately to provide the notification, I would hope that all local governments would be treated in the same manner. However, if the decision is to provide no pre-notification, that's a decision that treats everybody the same way as well. All we're simply asking for is to be treated similarly as cities and counties under the current regulatory process. Thank you.
Thank you, Mark. Chris?
Well, thank you, Mark. You kind of teed up my comment. Well, what's wrong with telling now everybody? The purpose of streamlining these statutes was to avoid, well, so for instance, like, let's cut out all the newspapers, let's cut out all the statutes this past year, really like streamlined public notification to the greater public. And Waterleak has been contesting that ever since. We think that is not good policy. If you want to streamline the protest process or contested cases or any of that sort of stuff, or applications or water right processes, hiding it from the public is never a good choice. And it's just very clear what was going on. But the statute passed and the rules will reflect that. But now here's a particular group who feels similarly, like, we would like to know what's going on, right? So we're going to carve out in rules a very specific thing for them. But what about the water right users who are not in a district or not a city municipality? What about giving them prior notice? And ultimately, it feels like what really ought to happen is that the systems that the department has for public access ought to be in the 21st century really streamlined. And I know that that's a process that's ongoing. And instead of giving specific, special interest access to information that can actually, as the ODF and W folks said, be a lot of work, just take the note in general that everybody should have as much information as possible without having to go on an Easter egg hunt for it. And I think that would be our preference.
Thank you. I see Jeremy.
Great, thanks. Jeremy, Central Oregon Land Watch. Appreciate the discussion and certainly agree with a lot of what was said from Kimberly and others. I also just wanted to note, at least from Land Watch's perspective, that local governments and special districts are pretty different. And I think one of the important things to point out as it relates to a lot of the discussion we've been having over the last couple of weeks is that local governments have land use authority and special districts don't. I think that's a pretty important point that I just wanted to put forth. Thank you.
Thank you. That was a very robust set of feedback there. We have lots to think about. So I appreciate that. This right here is exactly why we have RACs, right? To help us understand and maybe consider all the set of options. So
That was a very great conversation for us to think through. So with that, I'm not seeing any more hands. We'll be bringing this one back. I know you all know that. So Kimberly?
No, it was a different section in this subsection.
Oh,
I mean, it's still in
yes. Let's, anything else on 20? That's where we're at, right? 20? Yes. Go ahead, yeah.
I guess on the mapping stuff, I know, in 305, in most of these rules, you're referring to 305 as far as mapping requirements. And I know in-stream water rights are different in that they're in a stream, but I guess I would maybe ask the question, this seems a little, it might be difficult, for example, the township rain section and quarter quarters for the reach. I mean, what if it's an entire river?
Where are you?
I'm under section 00205.
Bottom of page 9. towards
Sorry,
the bottom. Yeah,
Okay,
Bottom of page 8.
big C at the bottom.
Oh, that's weird. Yeah, that's really weird. That is weird, huh? Hers says 9, mine says 8. So, but anyway, yeah, it's just a question.
sub-E.
Yes,
Yes,
yeah.
so-
Yeah. So it's just a question. It seems like
So
it's a bit more rigorous than.
So I will look to. Sorry, there's a lot of, there's so much going on all of a sudden. So, I think that, I'm curious, Danette, is this already what you all provide today?
No, we reached an agreement with WRD years ago when we started applying for in-stream water rights on what these maps would look like. Because oftentimes they do cover many miles of a stream reach. We've done some mock-ups to try to see what this would look like, especially with the quarter being on the map. And we're not quite sure yet that provides more clarity for the public on where these reaches are in the state. So we're still looking to have some further conversations on this requirement and how we can kind of clean up the maps and still provide the information that's necessary.
I would like to take a 5-minute break to reset this, if that's okay.
Sorry, to reset.
I need to reset the owl. Can we ask Greg to just speak and see if it's well, we know hers is breaking up. I'm just wondering if somebody else online would just say something so we can see if it's a technical issue or if it's. Greg, could you just say,
Yeah,
Or-
hi. Checking,
Okay.
testing, 1, 2, 3.
Okay, great, thank you. So I think we're okay. I think it was just a Danette.
Danette, for some reason, you're coming off very, scraggly.
Yeah, we missed a lot of what you
Something,
said.
Just to repeat, I understood what Danette said, right? And so they are essentially, for those of you that didn't hear, they're looking at this rule. And it is different than what they're currently required to do, so they're trying to assess what that would look like.
Raquel?
I want to, yes, hold on one second. I want to acknowledge up front for folks that we are, we have not had a chance to talk with ODFW about all of these rules. So there will be additional conversations with that. So Danette, I want to acknowledge that too. Director?
Isn't our standard practice to use river miles for reaches? I'm gonna look to Katie on that, and I don't know if they have a TRSQQ for the beginning and ending point of a reach. But my recollection was that the in-stream certificates are issued with river miles.
I believe so, and we have under sub A, the applicable lake or stream reach by river mile. And then sub C is what folks are expressing some concerns about. And so, yes, there's obviously room for further discussion with ODFW, but this is a staff recommendation in WRD to make sure that the public can figure out where ODFW's request is and the full extent of their request. So, however we get there, we want everyone who's interested in these applications to be able to find where these are located. And frankly, knowing a river mile, well, we in WRD and many of you all could figure out where that is, but the public can't go into Google and, figure out where something is by typing in a river mile. There's also, of course, the need to be a little familiar with the public land survey system. We do have our online mapper that allows for that. So really the intent here, even if it's achieved in a different way, is to make sure that anyone who's interested in participating in the process really understands the location of these applications.
Okay, so, I'm just gonna note, it looks like this one we need to have further conversations about. And I'm seeing so many hands, so we're gonna go to, Jen. And then we're gonna go to Greg and then Danette and then Austin. And then just gonna say, we are gonna talk about this one more. We'll get together with ODFW, and chat more about this, but I do wanna hear what everybody has to say about it, so.
Thank you.
Jen.
Jen Hubert, Deschutes River Conservancy, and I had this one flagged as well. It was just, I'm just thinking about all the applications that we do just for large properties alone. And the quarters for a really long reach with a stream that could like shift and move too, might end up in a different quarter. I think there's probably a better way to describe it.
Fair point. Streams meander, who knew, right? Okay, Greg.
Yeah, this is kind of more a technical comment on latitude, longitude using GPS. I was remiss in bringing this issue up when we were talking about mapping standards, but anytime the department is allowing the use of GPS to establish latitude, longitude, they really need to, I think, include certain standards because your measurement is going to depend on what datum you're using. There are several different datums that you can use, and so depending on what datum you're using, that actually affects the location. So if you're measuring in one datum but you're reporting it in another datum, or somebody's assuming that you're using another datum, your location could be off by hundreds of feet. It also depends on the accuracy of your measurement at the time you take the measurement, which depends on how many satellites happen to be in the sky above you at the time. Usually the device you're using will tell you that. But I mean, I think that anytime lat long is used, or I mean, GPS is used to determine lat long, it's, that needs to include certain standards. It needs to include, you need to at least report what datum you're using and what your accuracy is at the time. And I don't think those standards are established in any rules that are referencing the use of GPS. So I think that's something that we need to include, and it's got to be in, somewhere. Maybe here in these rules could just reference back to another rule somewhere, but it's got to be in the rules somewhere.
Thank you, Greg. Bryn, if you can note for us to evaluate that for Division 305 plus Division 77, that would be helpful. And we'll take a look at that. So Danette, then Austin, then Chris, and then Leah.
Thanks, Raquel. Hopefully I can maybe talk a little louder if that helps you hear me.
No, staticky. So
oh, good. I won't yell then. I just wanted to clarify that between using the map and the information provided in our application form, you can probably get a good idea of where these are if you use those two pieces together. The application actually does have the township section range of the upstream and downstream points identified. Those are not yet on the map, but we do use coordinates and an overlay of a stream layer so folks can get an idea where we're at in the state or the reaches. We also use GIS to determine our lat long locations. We don't go out there and stand at the upstream and downstream reach with a GPS and get those coordinates. So if that's something to be considered, whether it's GPS or based on GIS, that could be part of the standard.
Okay, thank you, Danette. Well, you'll be hearing from us on this one. Okay, Austin.
Hello, Austin Patch, Summit Water Resources. I'm stepping in for Ted Ressler. I just did want to touch on the 5 sub E sub B, the lat long discussion we've been having. The way that I read this, it does almost indicate a physical presence using a GPS system. And I do want to just make a point in regards to the safety of the staff, that some of these downstream points or upstream points may be inaccessible physically, and may have trouble with access to private property, etc. So I find it a little bit restricting and a cause for concern for the staff that have to actually ground truth it by a physical GPS system. I do like the idea of maybe adding GIS or standard surveying techniques in this provision.
Austin, thank you for that. Brian, if we can note to look at that also holistically for other rules, that's a fair point for us to discuss. Okay, Chris and then Leah.
Yeah, so I just wanted to go back to the comments I had with Division 305. Requesting that latitude, longitude, GIS, and the coordinates be used instead of solely using the PLSS system, keep both.
Yeah.
But really have that specificity, and I'm not a surveyor, so I may be not sure really what I'm saying, but I think one can go into GIS without going on site and get a pretty good idea of where the lat and longe is using the S3 maps and all of that technology. Because I agree, it could be like, there's a king in there and we don't want people falling in the king. And the other thought I had, which I think was already addressed, so is simply just ask ODF&W to consult on this. And maybe that might help solve some of these questions.
Thank you.
Yeah.
We will be revisiting 305, just FYI. I know that's another one that's coming back. Okay, Leah.
Yeah, regarding the township range section porta quarters and whether it's valuable or not to have the information in porta quarters. What I'm thinking of is if someone does a placard search to see what's in a particular porta quarter, is the in-stream water right going to pop up in the middle, or is it only gonna say now we have the two endpoints and not show that there's an in-stream reach that's covered by an in-stream water right? Like I would hope that that's getting into the placard. So I think that's why I would want to see the porta quarters, just so that information is easily available.
I don't know the answer to that question, by the way, so we'll note it.
I believe,
Oh, Sarah, yes, Sarah.
I believe the entire reach is searchable in our placard, so it is a good idea in my opinion to have porta quarters.
By the way, I just want to acknowledge, we have Sarah and Joan here who are in our tax section and have been helping on some of this stuff, and they're both nodding over here about this. So thank you, Sarah, for noting that, and Joan for affirming, for the support here. So Greg?
Yeah, a couple things. Just wanted to mention that the water right mapping program, if you put in the in-stream water right, I believe it does show the entire reach on the map, which I find very helpful. And then the other comment I wanted to make was that, the comments I just made a little bit ago, about GPS measurements apply also to any map generated using GIS. Same issues with datum and accuracy. Thanks.
Thanks, Greg. We'll note that for 305 plus other visions to look at. Okay. So, does anybody need a break? Anyone wants to keep rolling here? All right. So 27. I didn't flag anything on here to flag for you all. This is the 2025 legislation and that clarity over that suitable book language again. 29, again, this is procedural and 2025 legislation. And so I didn't flag anything on that one. This does do the two-step initial review process, consistent with what we've seen for new in-stream water right applications. And then we go to 31. Which I did flag for a couple things to just highlight for the group here, in addition to the electronic document stuff and all that stuff you've seen through the 2025 with the phase processing. Yes, there's also a land use compatibility provision here. So I know we've talked a lot about land use and so this one has a change related to the land use provision. And it also, so I'll highlight that for you. And then it also removes, this is that discussion that we've had on other rules, the request for affected local, state, and federal agencies to post a copy of the weekly public notice. I know we had some discussions at the last several RAC meetings around this, and maybe there's an alternative. So I know we're still evaluating that language, but that language does appear here. So just flagging that again. And then also removes the provisions related to the land use piece, which I'll have to flag. And I know we're still talking about land use stuff. Any comments on 31? Austin.
I actually have a comment on 29.
Okay.
This is going to be under sub 2.
Okay.
So there's a statement kind of down towards the bottom of the paragraph about the batch submitting in-stream water right applications in batches, and how a single communication can suffice for more than one application. If the communication specifies which applications the applicant would like the department to continue processing. So it doesn't specify the opposite side of continuing processing, which is notifying which applications the applicant would like to not process, not continue processing. So if the single communication for batches of these applications works for continuing processing, I think it should also work for stopping the processing. It's just not specifically stated in that sentence. So I'll just be submitting a comment on how that can include not processing, and so it includes that.
Got it. Thank you, Austin. I see what you're talking about.
Thank you.
We don't want 100 emails for each application, so we'll make sure that we make that clear. Okay. I don't see any other hands, so moving into 33 was just a technical adjustment. 37. So 37, 39, 43. Basically, the next several set, I did not flag things to flag for the group. So 37, looks like we've got quite a bit of rule cleanup and legislative consistency. 39, we've got the legislation, party status, protests, electronic documentation issues. 43, this goes to the contested case and protests. And 46 is also going through the contested case, protests. And then 40. So similar things to what you've been seeing. And so I see we've got, yes, Kimberly.
Yeah, just a small point, but under 43.1, that same point I've been raising every time.
Oh, yes.
About
the
137.
Party status.
Yeah, and also 183, 137. But the other point I was gonna make is under 2, and this again applies, I think, to all the rules. Is the standard you guys are using is if a protest is timely submitted, but it seems like it should be if a protest was timely submitted, and I don't know the exact language, but basically and meets the requirements for a protest, because otherwise people could just, pay the fee and say, I don't like what you're saying, protest, one sentence protest, and it would have to go to hearing.
I suspect we took this from statute,
Okay,
but obviously they would have to
right,
meet the Division 2.
yeah, so it's something, so maybe it's
So,
that meets the Division 2 requirements or something.
okay. Bryn, did you get that? Okay. And that I think would apply to anywhere where this language appears.
Yes.
So it's probably under 310 as well.
I submitted it in almost
Oh, okay.
310.
I haven't gotten
I
it there
think it's also
yet.
and transfers and.
Okay. Okay. All right, so. I think I left off with 47. Which is more contested case stuff, so you can feel free to stop me at any one of these. I just think a lot of this language is similar issues that you've seen. And 48, just a statutory reference update. 51, more contested case protest stuff. And then we get to 52, which is where I start to pick back up on things. So there was a lot, but I just kind of noted you've seen similarities and are kind of those contested case and legislative items. Okay, so 52. This one relates to the administrative hold provisions, right? Which I know there was a lot of discussion around on prior rules. So just wanted to note that this one does contain that language. So the cumulative length of extensions requested through administrative hold shall not exceed 180 days. Except upon the findings, so this is the parameters we put, by the director that a longer extension is reasonable and necessary for the applicant to engage in collaborative conversations. And the extension does not exceed 2 years. So that was the administrative hold piece, which I know we've had in other rules that I wanted to flag for you all. So I'll pause there, see if there's comments on that before we move into 54. Yeah, Brandon.
Collaborative conversation seems. What one might find collaborative, the other party might not. So I don't have a suggestion on how to make it any different. I guess I would just flag that collaborative conversations could be viewed by one of the parties involved.
So maybe we should just say conversations. Is collaborative necessary? Is there a particular reference?
I mean,
that
we
you
can think about that, but I think that's the intent, right? If people are trying to reach resolution
Well,
on
sure.
concerns folks have raised, we were, they don't want to just put it on admin hold to put it on admin hold or to have a fruitless conversation. So one could suggest another word if that might be helpful, but it is intended for people to try and work through concerns that folks have raised in a public comment process. And it is the same as one of the admin hold parameters that shows up under division 310. So like with consumptive use applications for in-stream water right applications from state agencies, we don't want these to just be lingering out there in application land for undefined periods of time. So this sets some parameters on what's reasonable and necessary to extend out processing times.
Consistent, what was the division that you referred to?
Oh yeah, Division 310 has an administrative hold section and
Thank you.
you're welcome. It's towards the end of those rules.
So 310 is a little different because there's some additional ones, but it does have, I believe, this provision in addition to those. Okay. So we're going to move to okay, we're gonna pause, we're gonna take a break. My foot's falling asleep. So we're gonna take a 5-minute break. And then we're gonna get into 54, which is conversion of minimum perennial stream flows. Okay? I can't say that my husband is not still asleep, but.
I did never had Michael's job though.
Okay, that's
Yes,
fine.
yeah.
All right. Conversion of minimum perennial stream flows.
You know how to have a good time.
Time to party.
Okay.
Put them all together, but never where the lunch break, yeah.
What number is that again?
That is 54. All right, so. This does a couple of things here. It removes a reference to a publication that would have happened in, well, decades ago, specifically 1988, so,
I think that's. Like,
Telegraphs are also important. That was a different, sorry, that was a different statute. We won't go there, but.
1888.
And so Kimberly, I see yours. We'll get to you in a second. It also implements 2025 legislation about, procedures for when a protest is timely filed and all of that stuff, the protest contested case items that we've been talking through, as well as Division 2, as well as that PFOs will become final if no protest is filed. And removes those revisions to the rules that have been superseded. So, Kimberly, would you like to, I saw your.
Yeah, I guess, the point on the publication, the idea when the In-Stream Water Rights Act was passed is that minimum perennial stream flows would be, converted right away. And most of them were, but there's some still hanging out there. So
Yes.
I guess, I feel like this takes away something for those. There's the Willamette ones, which I know are part of the, the larger conversation, but my understanding is there's some in the Umatilla as well.
So we would, under this, we would, maybe what you're saying is so the agency would have to do something so people could protest it. And so I think the point is the publication isn't the critical piece here. It's that we need to do something saying we're going to convert it. That's what's missing to you.
Yeah, like, for example, and I don't have the details here, but B says the flows the commission intends to condition and schedule a hearing. I just don't know where those stand, like, were the Umatillas did the state not move forward because they were protested, or did they just not get to them? I just want to make sure that the direction is not lost, so.
Yes,
maybe
so the
just
direction that I'm trying to get at is, I think what's missing here is that when WRD intends to take action on a pending minimum perennial stream flow that hasn't been converted, right? And that we would issue a proposed final order. And then someone can request a contested case hearing on that. I think the issuance of the proposed final order is kind of assumed the way this is written, and there should be a trigger for that, right? And I think maybe your point is we probably need to keep one. I'm not trying to put words in your mouth, but I'm hearing what you're saying and I'm realizing what's missing here, which is that if the commission let's see now, well, because it says now we would do this process through the PFO. So I think we just need to put in there that for ones where action has not been taken, we need to issue a proposed final order, expressing the intent to convert, right, without change to in-stream rights, or expressing the way this is written is odd.
Yeah, and I can talk to.
Oh, sorry, I'm not reading the whole thing. So
we need to issue a PFO that says, you know, whether we're intending to convert with the flows without a change. Or whether we're intending to convert with a change, and we would issue that PFO. And then there would be the opportunity for a protest. So I think we need to fill in that part.
Okay,
Does that make sense?
yeah, I'll confer with our attorney who works on these.
Yeah.
And maybe try and provide some suggestions. I don't have that today, just,
Yeah,
I'm
the
just worried
laminate,
about.
and there's, I can't remember if it's utility, there's another basin
Yeah,
where this is.
yeah.
That I know of, right, James, but I think it's a fair point that there seems to be a lead-in that is, missing here, so, fair point. James and then Chris.
Raquel, that's exactly what I was going to say, is that the deleted section 1 provides the context that's necessary for the new section 1 to make any sense, because I guess you have the title of the rule, but if it just starts in with requesting a contested case hearing on any of the conversions proposed, it's not clear what conversions are referenced and who's proposing them. So it needs something like when the commission intends to convert a minimum perennial stream flow to an in-stream water right, and then any person or agency. It's just kind of a readability suggestion.
Thank you, yeah, I see it, now, I don't know why I didn't see it when we sent this out to you all, but. Chris?
I'm just curious, how many are we talking about after all these decades?
I don't know. I'm just being honest, I don't know.
I think it was around 40, close to 40.
I have no idea.
I can get you the number, I have it somewhere.
That's good
So-
enough for me.
Okay, I'm like, I've not done that research and I don't, if we don't know it now, we don't have time to do the research right now, so. Cause we're focused on rules, yeah. Okay. Thank you for that question though, Chris. Leah.
Yeah, relating to that, just really quick, the top part that's being deleted was talking about how the commission would express its intention to convert these, and everything else in here is talking about like what the department will do. So I'm just curious, like, is it still the commission that's gonna have to make some statement of their intention, or is it just gonna be this PFO issued by the department?
I think I need to look, because we're missing an entire section, I think we need to work through that and look at the current statute. And then go from there. I think where we would go is, well, I don't want to answer that right now. Katie wants to answer it though, right?
Well, I don't have an answer, but I want to add a little bit here. So there were some really obvious changes to make. So something that was supposed to occur 21 days after a specific date in 1988, that language is moot, that needs to go. And then implementing House Bill 3544, that's what you're gonna see through most of the rest of it. So those are really obvious changes that we knew we needed to make. In terms of describing a full process for conversion of minimum perennial stream flows, it's not a quick thing to do in this rulemaking based on looking at the statute. And so we thought, okay, we can make these changes, but in terms of really getting into describing a process that's not really specified very clearly in a rule, that's another effort. So that's where you have to look at in-scope out.
Yeah, I still think we have to put in what the initial trigger is, which is if we don't issue a PFO, the rest of the rule does not matter. So I think we'll do some looking at that. I don't know the answer on the commission piece because we got to go back and look at the statute. This one, to Katie's point, it gets a little complicated because it ties into other statutes, and so we need to go then look at those ones, so.
Yeah, and I guess as part of that, we don't wanna, I hear what you're saying, Katie, but for instance, I don't know what was on that list, and so if the ones that haven't been converted were in fact on that list, I think that raises some questions as to process. In other words, if the commission created a list and said, we're converting these Umatilla ones, and the department didn't follow through, I'm not sure we restart the process. I think we move forward. Anyway, I'll think about it some more. I just don't want to lose what was done in the past just because time has gone by. Yeah.
That also assumes we can find the list, though.
Right.
So,
To my point,
I just wanna also acknowledge there's
Yeah.
that, so. Okay,
Listen, Megan.
we will do some additional work on that one. Thank you all for pointing out things that quite honestly should have been obvious when I read this through the first time, but hey, we're doing a lot of work here, so thank you for that. Let's go to 65. Let's see, so this one has a lot of the same things and it's more clarifying language as well as the same provisions that we've put in place related to injury and enlargement and who references, all of that stuff. But the one I wanted to point out, this one goes back to the ENAF discussion, I believe. Although I'm not seeing where that is right now. I think it's under 5, is that the language that's getting rid of the ENAF piece?
Yes.
Okay. So just pointing that out, that determining whether a proposed in-stream water right would support a public use is that ENAF piece that we were adjusting for. Am I not on the right thing?
No, I think you are. I just thought there, we'd have to check, but I thought there might be a little more to that, as in, how would it not be a public use for somebody to convert a consumptive use right and put it in stream? So I could be wrong in my movie discussions, but I thought this wasn't necessarily just an ENAF question.
Okay.
But I will defer to you both on that.
Question or comment from Chris?
yeah, briefly, just, in the rules summary that you have, highlighted gray. It refers to the department's authority under ORS 537-342-343 subsection 2 to make final determinations, including to limit the level of in-stream flow, does not apply to these types of applications. Is that in reference to number 5 here?
Yeah, that's what I was just noting.
Yeah.
Yeah.
Okay. I would be interested to know where the department thinks that particular subsection number 2 does and doesn't apply. I know that it comes under the proposed final order heading in the statute, which is 343. I'd be interested in learning more about where 343 subsection 2 does and doesn't apply, because if it just applies to proposed final orders.
So we're saying that the ability to limit is, it applies to new in-stream water right applications. It does not apply to leases, transfers, so that we're now in the transfer section.
Yeah,
Or,
Okay.
the HW.
thank you.
Okay. Okay. So 70. For 70. We did make some changes here to the types of rights that can be transferred in stream. And we also clarified the requirements for above ground storage transfers to in-stream. And then we also removed language related to, again, that ENAF and limiting the flow. So that continues on in this section here. So, what I want to, and Katie, maybe this was your point, is that, well, no, I won't go there, but, so with that, remember that whole thing, transfers of stored water, that some of you had the pleasure of working on back in 2017? If you didn't, you are so lucky. There's been a whole saga over that, right? And since then, there's been some legislation that addresses some of the issue. There's also been a court case, and so this is us doing some clarity here. It is also us doing some clarity around what we need if you are going to lease or transfer an above ground storage rate. So that's some of the changes you'll see here. Because those are a little more complicated. So we've got some of those provisions here related to that. So with that, I'm gonna go to Kimberly.
I just had a question. Are you talking about a change in character of use of the storage, right? It's, in other words, that's what we have seen a lot of, right? Where people will have a, whatever, irrigation storage right, and they want to peel out part of that for in-stream, which is changing character of use, as opposed to getting rid of the storage project altogether and converting it. I guess, what do you,
So
what subset are you talking about?
yeah,
here?
so it's important to note that there is flow augmentation,
Right,
right?
yeah,
That would be a secondary water right for
Right.
flow augmentation purposes. You're continuing to store it and then you're releasing it. Remember that definition of in stream?
Yeah.
That's the natural part. So this really is about you saying like, hey, instead of storing it, I'm going to protect it in stream. So that would mean you're not storing it.
you're not
anymore.
storing it.
Does that
Okay.
make sense? You were gonna continue to store and then release, then you would go and go through the transfers provisions and flow augmentation.
Though you can, I think there's a provision for ODF and W to apply for stored water. Maybe I'm confusing myself. I just,
That might be on the new water rates
Yeah.
side.
okay, sorry.
Yeah,
Okay.
so, yes, I know it's your basin, it's driving a lot of this, Jen.
Yeah, I think that, so, we have some conserved water projects. We're going through a whole different process right now for new things, but we have earlier ones off of Crescent Lake that are creating in-stream water rights with the use of the volume storage.
So that's Division 18.
Okay.
ACW, right? So if
Mhm.
we're talking about an allocation of conserved water project,
Right.
that's a different set of
know.
rules. So, so yeah, that wouldn't be, this particular one. Lisa, did I cover everything that you were?
Yeah, I think so. I guess Kimberly, did that answer your question or?
I think so. I think I just need lunch.
Oh.
Well.
Now, that's something we can agree on.
I can tell all of us are kind of like, oh, we've gotten into. Okay, so the other point that I realized I wanted to make on this, because apparently we're all thinking we need lunch, is that just note here that remember that discussion about groundwater, right? That's integrated into here for clarity purposes. So we're talking about leasing service water right, a surface water storage right, or the use of stored surface water. Right,
And this is the permanent in-stream transfer section or kind of.
Lisa, we might need to look at this, or the use of stored surface water. Shouldn't that be flow augmentation? Should that be in here? We might need to go look at that one.
Where are you?
Sorry, so two. In
Page
our attempt to
29.
clarify, we might have
But that's-
some reservoirs are issued for the,
Yeah, that's what I was trying to get at. There's like the storage right, there's the secondary water right.
Yeah,
And
but
so-
we're not saying you can lease a secondary, right? Are we?
Yeah.
Or transfer secondary, third water. That's,
cause it's the use, right?
the use of the stored water.
Okay, we're gonna have to have some conversations because we've now we've fuzzied the water over what is, how's that not a flow augmentation, right, if you're storing it?
A flow augmentation right is the secondary water right.
I know, this is, which would not apply in this section.
It's the use of stored water.
Say it's the use of irrigated water from storage. So you're using the water to irrigate, and now instead of irrigating, you're going to these for transfer
I
water.
fully understand that, so how's that different than a flow augmentation rate? Is that the same thing?
Well, it's dry, you're a secondary for use. of
Sarah's
storage.
getting it now, she's giggling. Okay, we are going to take a break
You have Chris over here.
and we're gonna go to Chris.
This is legacy, thank you.
And then, oh, okay.
sorry.
And then, so we're gonna, when I say take a break, we're gonna go to lunch. That's what we're gonna do. And, maybe the staff here will huddle with me because now I'm confused and that's never a good spot to be in. So we will huddle, we'll come back to you, maybe with answers, maybe without answers. So we'll see. Okay.
For folks online, so a reminder, we're gonna end this meeting, and then if you're gonna join us after lunch at 1, that's when we're gonna resume. You have to sign in using the MAC 7 registration. I did drop that in the chat.
I need to look.
Is there anybody online that's confused about that or need clarification before we end the meeting? Just want to make sure. See thumbs up.
Yeah.
Okay, all right.
We don't want.
Thank you.
That is.